Fine.
Yeah.
Okay,
Okay, here we are back at Ways and Means, and it's 2:50. We have Mark Langen here from the Vermont Bar Association. He's going to talk about probate trust law section. Welcome.
Thank you. So my name is Mark Langen. I am the head of the probate and trust section of my law firm, Dinsey. We're the oldest law firm in the state. We were formed in 1917. I was not practicing. No, just if I can digress too, we were formed by Warren Austin and Bill Edmonds, and Warren Austin left the firm to become senator for Vermont in the Capitol. And then he was appointed as our first ambassador to the United Nations by Truman. So we had to change our name. Once an attorney leaves the firm and has another job, we can no longer use their name. If they die, then we can use their name. And so Dinsey, John Dinsey, who probably died in 2015, he joined the firm in 1953. But we still use his name, and that's the only name that we have. Besides being at the law firm, I am the section chair of the probate and law section of the Vermont Bar Association. I not only have my law degree, I have my master's in taxation from Georgetown University. And I am a fellow in the American College of Trust and Estates Council, I have been state chair for a while. My term of duty has ended in that regard. And one thing you might want to know is that I basically worked with the Commissioner of Taxes in 2015 under the Shumlin administration, where we redeveloped the estate tax in Vermont. And it was a very complicated system, and we straightened it out. So I was an integral part in the drafting of that statute. As section chair, I have been very active in bringing many uniform laws to the state, to the legislature to pass. Probably the first and largest one was the Uniform Trust Code. So I was the chair of the committee that brought the trust code to Vermont. But I've had a number of other uniform acts come up through, and many of them are related to trusts that we have done. So it's an area that I'm familiar with. Let me just give you a background, because I go through these speeches with my clients all the time. So a trust comes by its name quite honestly. It is a total English invention, not known to the French, not known to the Spanish, not known to the Germans. It's English through and through. And what it is there's usually three parties in a trust, and it's one person who gives money to another person in trust for a third party, right? And you're giving it to that person, and you're hoping they don't run to Rio with the money. You are trusting them, and that's how it gets its name. That's all it is. And there are many, many forms of it, but that essentially is the core. You have this person who is sometimes referred to as the donor or the grantor, or sometimes the settlor if they establish the trust. They give it to the trustee. There's no other names for the trustee. It's just the trustee. And then they give it to, and it's held for the benefit of what are called the beneficiaries. Under old law, it was the Seneca Trust. That was a Latin word for beneficiary. So you've just got this triangle. And that's, that's basically what trusts were, is you're giving money to someone else to hold for the benefit. And sometimes it's because you want someone to manage the money for your children because they wouldn't be able to handle it, and you may die. So you give it to someone to help manage assets for another person. So when I was in law school, I thought that, I basically thought trusts are for rich people. Only the Rockefellers and the Mellons have trusts, so they're bad. That's not true anymore. is everybody has trust. We use it pretty much every estate plan that we do. We incorporate a trust. So trusts come in a couple flavors that you have to sort of understand what we're talking about. So once a trust can be revocable, where the person who sets it up can change their mind and to amend it at any time. And of course, the opposite is irrevocable. So trust can be revocable or irrevocable. Trust can be embedded in your last will and testament. And if it is, we call it a testamentary trust, and it only comes to fruition after you die, and it gets funded with your estate assets. So we call them testamentary trusts after last will and testament. And I will digress. Another part of English law. Why do we call it a will and last will and testament? Because this dates back to William the Conqueror, 66. Okay. So before that time, all property as it transferred from generation to generation was done by the clerics, by the priests, because they were the only people who knew how to read and write. And what happened is when William the Conqueror took claim of England after I think it was his uncle, Edward, he wanted to get control of the land. So your will conveys your land, and your testament conveys everything else, cash, furniture, everything else. So there was, but then after the probably Protestant Reformation and stuff like that, the king basically stretched over and said, no, I'm taking control of testaments too. So everything is now a legal process. It's not bifurcated between the legal courts and the ecumenical courts. So it's been merged. It's your last will and testament. So testamentary trust. If a trust is written during your lifetime, we use the Latin word inter vivos. Inter meaning during, vivos during life. So inter vivos. Some people have anglicized it to living trust. So we have those. And then we have another one that is important for my clients to know. It's a IRS tax code issue, which is what we call a grantor trust, which is when you create a trust and you may have put this money in a bucket, but you are still considered to be the owner of the income, and you have to report the trust income on your 1040. So that happens quite a bit.
You're not entitled to take the principal.
Pardon me?
But you're not entitled as the grantor to take the principal, just the earnings and interest.
Well, it depends on what powers you retain in your. I'll digress and tell you why. What happened is that probably in the 30s and the 40s, when we had much more progressive brackets because our top bracket right now is 37% on income. It went up to, when this is sort of curious, I find, is that when they asked people in the MAGA movement, make America great again, they said, to what year are you referring to? When was America great? And they said, 1953. And you know what the top bracket was in 1953?
80.
90%, 80-90%.
Right.
It's only 36% or 37%, But anyway, so we've had times where the bracket has the Congress has moved this bracket up and down quite a bit. And what was done before the grantor trust rules was that rich people would put their money into various trusts. And so none of those trusts would go up into the high brackets, right? So Congress basically passed section 671 to 677 that says, hey, grantor, if you have retained a certain power over this trust, then we're going to treat you as the owner of that income, and you report it, stack it on top of your other income. That catapults you up into the higher brackets. We're not going to let you get away. It's a perfect, they just shut down the rule that you could do that. The problem was that in 1980, so that's probably, grantor trust rules probably came in maybe before World War II. And then in 1986, what they did was they scrunched down the brackets. So trusts and estates had the same brackets as you and I do, 10, 12, up to 37%. But an individual hits their top income tax bracket at the IRS at 500,000 and a married couple at 700,000. You know what a trust hits at 37%? 16,000. So everything over 16,000 in the trust is taxed at 37%. So you don't want to be you want to be a grantor trust because you're probably in a lower bracket. You might be in the 22 or 25% bracket. It's made it very unfavorable to leave income in trust. And the way that it works at the federal level is that to the extent that a trustee distributes out assets to beneficiaries, it will carry out income for income tax purposes. So it's a little bit complicated rule. I say it over and over again because clients don't get the idea, but I had a great case. So I had a case where the trust had a Cadillac and the surviving spouse said, I want the Cadillac in my own name. So we had about $5,000 of interest and dividends in the trust. They were sitting in a checking account. The trustee issued a new title certificate in the name of the surviving spouse. The Cadillac was worth $9,000. Okay. To the extent you distribute anything out, it carries out income for income tax purposes. So we distributed out a Cadillac for $9,000. And guess what? She got a K-1 from the trust saying that it carried out the $5,000 of income, even though that cash was sitting in a checking account. She has to pay the income on that cash or interest, even though she got a Cadillac. She can't like chop off a part of the Cadillac and say, I'm going to pay my taxes with the front hood, She's got to come up with other money. It's sort of like phantom income. So that's kind of the thing. So let me circle back as to what I would say in 99% of the cases that we basically use trusts to avoid probate administration, so that we don't have to go through the probate courts, and because it can take a long time to get through probate. People want to move on with their lives. So it's one of the many techniques of avoiding probate administration, and it's become super popular in the United States. So everybody, even people with the most modest of means, it's not, as I say, it's not for rich people. It is for everybody, because we use it as a probate administration thing. And, largely the way that has occurred of late, in fact, I was just looking at this, I think when I talked at House Judiciary just recently, I was looking back to 1976 when I was in law school, that the federal exclusion amount at the time was $120,000. So when you died, the first $120,000 was not taxable. And then also at that time, what you gave to your spouse, it wasn't unlimited as to what you could deduct. It was the greater of half of the estate, or $250,000. And that jumped up to, it was an index for inflation, went up to 175 for quite a long time. And then right around the time that George W. Bush became president, there was the exclusion amount was, it's about $1 million, $1.2 million. Okay. And so each the husband and wife could use their exclusion before the estate tax would kick in. So that's what, 2.4. Okay. And George W. Bush wanted to get rid of the estate tax, and he called it the death tax. And it was gaining a lot of traction. And I thought, because I knew that even at that level, it was hitting about 2% of the population at that time. And yet a lot of people wanted to get rid of the estate tax. And Time Magazine did a poll, and they found that 19% of their respondents thought they were in the top 2% of wealthiest Americans. I thought, it's in America, great. But, and since then, what's happened, it was indexed for inflation, and then we had a few years at 2 million apiece at the federal level. And then it went up to 3.5. And Vermont had always been coupled with the, our estate tax was coupled with the federal, but then they decoupled when it went to 3.5. And really what they knew it was going to 5, and we were at 2 and at 3.5. And so I think they thought, where's the middle ground? And it was at 2.75. And therefore we were at 2.75 for a really long time at the state level. But at the federal level, what happened is that it was scheduled to sunset at the end of 2010. And it did, in a way that it did, at the beginning of 2010, we had no estate tax. And then this guy, around in January, a guy by the name of Dan Duncan died. And Mr. Duncan was the 9th wealthiest American in the United States. He came from oil money down in Houston. And he had, I think, about $9 billion. And then in February, George Steinbrenner, who owned the New York Yankees, he died. So what happened was, and this is a super important concept of planning today, is that when assets are includable in your estate for estate tax purposes, and they're inherited, for income tax purposes, another chapter of the code, they say your assets, the basis of your assets will move up to the date of death value. So we call it step up in basis. So the income tax, the capital gain, the built-in capital gains goes away. Okay. And when I was learning this in law school, they said, well, there's probably 2 reasons why Congress did this rule. Number one is they didn't think that you should have to pay an estate tax and an income tax, double taxation on the same money. No, they didn't think that was right. Number 2 is the only person who knows what the basis is now 6 feet under. This is a real problem. It's a practical matter. So why don't we just move it up to a date of death value? So when you take away the estate tax, if we eliminated it, then nobody gets to step up in basis. Nobody. That means like someone who has an estate of $600,000 and may have a house. No step up in basis for them. So I think that somebody, like tapped George W. Bush on the shoulder and said, you can't get rid of the estate tax because what you do is you think you are, helping the wealth, but you're going to have a broad-based income tax on everybody. So they said, oh, okay, we can't do that. We can't do that. So what they did is they had this cockamamie scheme that was in section 1022 of the code, where they said, okay, well, we'll give you, if the estate tax exclusion is 2 million, we'll give you 2 million executor to play with, and you can dole out basis to the beneficiaries. Well, isn't that a nightmare? Because the kids of the decedent are going to be saying, yeah, I'll take that, but I want some step up in basis with it. I want to, they would be haggling over the basis, let alone, the furniture, So but fortunately, that never came into being. So back to 2010, what happens is that December 17th, 2010, Obama signs a bill that says, hey, we're reinstating the estate tax. It's in effect this year. But okay, for you people who died before December 17th, we're going to give you the option. You can either not pay the estate tax, but if you don't pay the estate tax, no step up in basis. Or you can pay the estate tax and you'll get the step up in basis. So they gave everybody that option. And then from December 17th, we were at a $5 million exclusion. And that exclusion, that period of time from 2010 to about 2019 was our period of economic, what they call stagflation. We had very little inflation during that period of time. So that 5 million just wrapped up. And until 2019, it made it up to 5.5 million. And so along comes Trump in 2019, And Paul Ryan has the Tax Cuts and Jobs Act ready for him, and he just signs on. And what they did was they said, we're going to double it. So we went from $5.5 million to $11 million. Everybody in the United States had $11 million exclusion. Okay. So then, but based on the Office Congressional Budget Act of 1976, they had to sunset it. And so it was to sunset at the end of 2025. So we were, as planners, we were thinking about, oh, this is going to go back. It would go back to what the 5.5 would have been indexed for inflation, which was about 7 million at that point in time. But then along comes the new tax act, the big beautiful bill, and what they did is they stopped it from sunsetting, and it would have been indexed for inflation, would have been in the $14 million mark, but they said let's round it up to 15 million. So we now have a federal estate exemption of $15 million per person. So that means that a family can transfer close to, a husband and wife could transfer close to 30 million without taxation. This is affecting less than 1/10 of 1% of the United States. So it affects, so virtually we have very little, but the super wealthy, they aren't really too concerned about the exemption amount because 15 times 2, 30 million, that means so little when you've got billions and billions of dollars. What they're concerned about is what's the rate. They want to push down the rate to 35%. And it's right now at 40. It has been as high as 50. So anyway, that's a little bit digression into the estate tax, but it's probably good to know that. Yeah, I think that's what a lot of times what we do in planning is that the government has given you these exclusions, be it Vermont gives you a $5 million exclusion, or the federal government gives you the $15 million exclusion. And we want to make sure that our clients afford themselves of what the government has given you. So there's a very famous tax case called Helbring versus Gregory. And in it, the Supreme Court said, basically they said, you can fashion your affairs to avoid taxes. You cannot evade taxes. So they made the difference between it's okay to fashion your affairs, you know, to reduce, everybody has the right in America to do that, to fashion their affairs so they pay the lowest tax possible. But you cannot cheat the government. So, you can't lie to the government and stuff like that. So they've done a pretty good job of shoring that up, I think, And one way that is important is that now tax preparers, they sign the return and they are kind of on the line for penalties of perjury if they lie. So that we have lots of clients who may have fanciful ideas about thinking about how they might get around a tax or something. And I say, yeah, you're thinking like a lawyer, but here's why it won't work. So anyway, so on trusts, generally, as I said, they are very popular as a probate administration matter. But let me try to explain, maybe give you an example of the classic estate plan. And that is that in Vermont, let's say we have a $5 million exclusion, which came, I think, in 2021. So at the federal level, this is an important concept. It's called portability. At the federal level, let's say I had a client who was very, very wealthy, and when his wife died, she didn't use any of her exclusion. And at the time, it wasn't 15 million, it was like maybe 11. And in portability, what at the federal level, they say, if your spouse did not use their exclusion and they are your last deceased spouse, then you can tack on their unused exclusion onto your basic exclusion. So if it wasn't used, you can say, and so when he died, the second he died, he went from 11 up to 22 because his wife didn't use it. Because the theory is the government saying, yeah, we're not too concerned. Each spouse should get the 11 million. And if they do, we're fine how they use it, how they divvy it up between the two of them, but they can pass, we're not going to be so very strict that you have to sort of figure out who's got what. We don't have portability at the Vermont. So as I tell my clients, if you don't use it, you lose it. So part of our jobs is saying, how are assets titled? Are they titled in a way that it will be includable in your estate so that you can use your $5 million exclusion? So that's it. And then usually what happens when the first spouse dies, we have an unlimited marital deduction. So we can zero out the tax, but that deduction part gets added to the estate of in a sense it does, it get added to the estate of the second to die spouse. So we catch that. And so we only get the 5 million for the first out. And then the second spouse has now got this bump up of the marital trust, but they can use 5 million for their assets. And then anything over that, we pay a Vermont state tax. That's kind of how the system works.
So our concern, thank you for that. That's a great overview. A previous presenter was talking about how individuals can avoid paying taxes. It's tax avoidance, not. And so just wondering about with your clients and setting up generation skipping trusts and other forms, if that's a major thing that we should be concerned about and people moving assets or moving income so that's not coming into the state coffers. That's kind of what we're thinking about is to looking at the revenues of the state.
Yeah. So, and I think that it was interesting, in my work with the Shumlin administration that we talked about a few of those concepts. So one of the concepts that I talked about with them was portability, because my section members said, please, Mark, get portability passed. And they said, no, we're not going to, so we don't have portability at the state level. The second thing they wanted passed, and this is something that I brought up with the commissioner. She said, Maine has a rule that says that if a non-resident owns residential property in Maine and they put it into an entity like a LLC or something, they'll see through it and they will subject it to tax. And so I asked the commissioner to ask the governor, do you want to do that? And they got back and said, no, we don't want to do that. Because I think that the negative aspects would have outweighed the positive aspects of that. So that would be my guess, but no, I don't think that the trust per se, there are certain things that trust can do that are totally within the boundaries. Most of these rules are all at the federal level. So there's not much that Vermont can do, because Vermont and most states are not in the business of trying to, they don't have the strength, the staff to look into what's includable in a state, what's deductible. They just piggyback off the IRS, and they piggyback off the IRS rules, and they piggyback off the IRS auditors. And they just sort of, and Vermont's not alone. Almost every state in the country does that. I don't think there are any independent that are so detached from the federal that it's very much like we do with income tax, We are totally, what's deductible, what's includable in gross income, what's a credit. Those are all federal rules that we just piggyback on is the state. Most states do that. It's easier.
Recently selectively decoupled from all the corporate income taxes. So,
Yeah.
Anyway.
And it becomes more of an issue because that was a big thing about Tax Cuts and Jobs Act, with the corporations really benefited there. But so there are certain, like I'm thinking of a technique that sometimes you can put an insurance policy in a trust, and it doesn't have to be in a trust because the federal rule says, hey, owner, if you are the owner of a policy on your life, and when you die, the death benefit is includable in your estate, right? So the whole death benefit. So all you do is figure someone else to be the owner, and that sometimes that's your kids. Sometimes people will just transfer it to their kids and say, you be the owner of this policy. And then if I die, it's not includable in my estate because I don't own the policy. So you don't need a trust to do that. But a lot of people do because when it's usually a big amount of money that the death benefit comes in, it's usually you want to make sure that it's going on for the surviving spouse and children. So, but it's not the trust per se that does that. It's just who's the owner of the policy. So, yeah.
You mean the beneficiary?
I mean,
When you say the owner of the policy, you mean the beneficiary,
no, I mean the owner.
the owner who's paying for the policy?
Usually, yeah. So like frequently, I'm a trustee of many insurance trusts. So I get the notice because I'm the owner, the company knows it, and I write the person who's the insured and I said, hey, would you like to make a gift to the trust? And they send money to me and then I use the money to pay the premium because I'm the owner, So when they die, then it's not includable in this estate for estate tax purposes. That's a federal rule, yeah.
Representative Volk.
Can I take a slightly different direction from the question? I don't know if you deal with donor advised funds at all.
Mhm.
And what do you see happening in that space, and what do you think is the impact of that? I mean, you've raised some questions about charitable giving, but how do you see that developing in Vermont specifically?
Oh, in Vermont?
Yeah.
When I look at, before the invention of donor advised funds, the way that we did it was when people wanted to set aside money, permanently set aside money for charity, they would create a private foundation. Private foundations took two flavors. They took the flavor of the not-for-profit corporation, where you file with the Secretary of State, get a charter, or they use a trust. And in fact, when you go on IRS Form 1023 about trying to get the entity to be exempt from income taxation, there's usually, the first question is, are you a not-for-profit corporation or are you a trust? The rules of that says. So then, and we did those, and the income tax return for a private foundation is called the 990 PF private foundation. When I did my first one, I think it took me 40 hours to complete the private foundation income tax return. It's a bear. And well, because they're asking you for budgets and projected budgets, and it just goes on and on and on for pages. But the taxation rule is that the private foundation can be subject to a 2% excise tax unless it distributes essentially 5% of the fair market value of their assets out each year. And the rules are really flexible. They can say, oh, you can hold up for 1 year, then do 10% the next year, and stuff like that. But that's it. But it's kind of where you want to maybe control what the investments are and what you're invested in and that sort of thing. Whereas, so then the brokerage houses came up with the concept of, we'll take care of all that administrative stuff for you. So we're going to create a donor advised fund. So you put the money in and it will get pooled, but we'll keep it on the books as to what your money is. And all you have to do is think about your charities, who you want it to get, so they don't have to worry about, if they're a not-for-profit corporation, they don't have to do the annual report every year. If they don't have to do the 990 PF, and you've got some professionals who are working on this. And so it's great for our clients. They can go in and say, oh, this, let's, they figure out where they want to do it. And they usually do it on an annual basis because they're looking to get that 5% out each year, so it's taken away the administrative issues. So it's been it's been easy for people, much easier for them to give to charity. I think donor advised funds are great. And what usually happens with a donor advised fund, obviously the donor is an advisor. And usually the institutions, the two biggest players that I recommend clients to are Vermont Community Foundation and Fidelity Charitable. I think that those two are really big in that space. And I misspoke. I thought the Vermont Community Foundation would be very Vermont focused, and they know what's going on in Vermont, and but they have the ability to go outside Vermont, as a donor advised fund. So you're not hamstrung to go to like Fidelity if you want to help charities that, let's say, I think the number one charity on the big board right now is Doctors Without Borders. So the charities, this is sort of interesting. So, because I have a woman from American Cancer comes up and visits me every year, and she has a list who are the top ones. And for a long time, it was St. Jude's. But I think they've just been bumped by Doctors Without Borders, and American Cancer is slipping. American Cancer and American Heart used to be the number 1 and 2, but they've sort of slipped on that. So,
Representative Brannigan has a question.
Well, I got 3 things. First one, I asked you, when you first sat down to talk, you told us about the giver, about the 3 people.
yeah,
The giver, and then the person,
the trustee.
okay. And then for another person, the child so where is the owner? Is that the trustee? It's the trustee. No.
Well, that's a good point. So technically it's the trustee. The trustee is the legal owner. What happens is in trust law is the title bifurcates, and title is split between the trustee who owns bare legal title and the beneficiaries who own what is called beneficial title or equitable title. So title kind of splits at that point.
All right. Okay, that's beyond me. But
Okay, well, let's say you have a piece of property, okay? And in the trust, and trusts are not entities. They are not like LLCs. They are not like corporations. They're exactly what I describe them as. They are relationships, and therefore trusts are not taxable. The fiduciary is taxed. The title has to go in the name of the trustee, and the trustee has to pay the tax. So there's not an entity type of thing. It's just a relationship, So, in fact, we call it a fiduciary income tax. We're taxing the trustee as on the income of the trust. So, if let's say the trust owns a house, then the deed will read the trustee is conveying it to John Doe and Jane Doe. So we call it a trustee's deed. So there's no, I once, early in my career, I saw a deed that was drafted by a well-known attorney here in Montpelier, and he drafted it to the trust. And I went, what? You can't do that. You didn't do anything. You didn't convey this property because it's in the name of the trust. You got to do it in the name of the trustee. So this legislature, in its infinite wisdom, sort of helped people out. They passed a statute that said, if you transfer to the trust, we will deem it as if it were transferred to the trustee. Now, they didn't say it's okay to transfer it to the trust. They didn't say that. The legislature said, no, we're just going to deem it to be as if you had conveyed it to the trustee. So we got out there. But the trustee, so when an account is opened up at, let's say, Merrill Lynch, it's under the name John Doe, trustee of the Mary Doe Trust.
I got 2 more things.
Yeah.
First, I just want to share with you that our previous speaker, well versed professor in tax law gave us a great presentation for over an hour. But in his presentation, he hinted at something that I do occasionally hear. And it really bugs me. And I want to just share it with you. He said that the attorneys, he used another word, but he meant the attorneys and the CPAs not beyond being slick. And if there's a hole in the law, they'll take advantage of it, even to a questionable extent. That really bothers me, because in my experience, so I live in Georgia, which is just south of St. Albans.
Mhm.
All the CPAs and all the attorneys that I know, and I admit that I have a sheltered little world, okay? They are so ethical and so honest and so fearful of making a mistake because they lose their license.
Yeah.
And you just said something about that they are held to the charges of perjury.
Mhm.
If it's discovered that they knowingly did something
Mhm.
incorrect on the return.
Mhm.
So I just want you to know that, because that belief that the CPAs and the attorneys are all kind of sleeky, that has been here since I first got elected in 2002. And I don't know how to fight it. And I shared it with Shep Smith years ago when he was on the committee.
Mhm.
And he understood what I was talking about. And Shep, he just laughed about it. But I think that it bothered him too. And so just want to tell you that. And then the last thing, I can't read my own writing here. I'm sorry, I can't read my writing. So I don't know what the last thing is.
Can I ask you, just to clarify,
Yeah.
the second point that you were making, I don't know if I grasped it. Is your concern that the public, the lay people are concerned that the lawyers and CPAs are crafty or something?
That somehow they're not honest and somehow not playing by the rules. And I don't observe that at all. I observe the opposite, that in fact, if anything they're dealing with is questionable at all,
Oh, yeah.
or might be interpreted as questionable, they don't do it.
Yeah,
They run away from it.
Yeah.
And they tell their client, no, I'm sorry, I can't be party to that.
Yeah.
That's what I have seen.
Uh-huh.
And it bothers me out there that in the public, even in this building, there's a feeling that the lawyers and the CPAs are, and I think it's behind this desire to, now I remember what the third thing was, but it's behind this desire to, which is the third thing, change tax law to prohibit that kind of thing, to beef it up, to tighten up the rules so that there is no way to get around it, and Vermont can collect its full due out of taxation, which I agree with also. Everybody has to pay tax. That's how our state functions. But it's not that anybody is, not that I have witnessed in my years here.
Yeah.
Honestly, I haven't. Jack Smith would never think of it. Michael Bahalski, no way. I mean, it's just beyond them. And Emily, it's just not done out in the professional world. But yet there is this belief that those guys are sliding through, they're slick, they're, come in with a nice suit and a white shirt. And let me tell you something, not true. These guys that I know, Northern Vermont, which is the realm of my universe, they aren't.
Yeah.
So I don't know if you can fix that or not.
No, well, the perception,
Why not?
I am one of my annual gigs is I am the last speaker with a former law partner of mine at the UVM Tech School. So the UVM Tech School gives a presentation in Burlington and Killington, where we probably present in front of 500 accountants. There might be a few attorneys here or there, but it's basically for accountants. And our thing, we're the last leg, and people really look forward to us because we are, we're the year in review. And we go through the cases and that sort of thing. And my perception, and this is probably, we talk about these cases and sometimes, all the CPAs are, they're very honest and they would think, what was this taxpayer thinking? What did they, the stories are almost comical as to where they were going. And, the attorney tries to do what they try to do. But I think that there is just harking back to Halvering versus Gregory, you can fashion your affairs in any way you can to, let's say, if the government says we're going to let you deduct your auto loan, that you might think about buying a new car because there's a lot of ways where the government has used the tax code to help and to steer society, So for example, the medical deduction, as you get late in life and you go to an assisted living facility, those huge expenses of medical are going to be deducted. And my mother didn't pay income taxes for the past couple of years because her medical expenses were so high because she was in, so the things that, and there's those are all policy decisions and stuff like that. But, we do have techniques that we use, but they're totally, there's an ongoing discussion with the Internal Revenue Service and with the tax court and with Congress as to what the rules are and what they aren't. And my job is to figure out where do you stay within the rules and not to do anything that would be outside the rules.
And I think the CPAs follow that for the most part.
Yeah.
Follow that too. They want to know what the rules are. I know the CPAs will pore over state legislation at the end of the fiscal year. And, look and see what we've changed and what we haven't changed and where there might be a legal loophole or maybe some opening, but nothing illegal. And it just bothers me that a lot of people continue to that it's not, that they'll do things and they're just, covering it up so we don't catch them.
Yeah, I find the group that I speak to, the accountants, are really an honest bunch. And, I think also with my experience, when I started coming up to the State House for that is how I don't think the general public has an inkling about how civil these conversations are within the State House. Because of what they see at the federal level and the fighting that goes on. But this state, I find the legislators in the State House are incredibly civil and open to discussion, and it's so, but they're,
It's not.
but I'm not sure if public perceives how civil it is. Yeah.
Representative Maslin had a question about 2 Brannigan questions ago.
That's right. I was gonna ask. I thought we were being civil. I understand. On my, say I have a big piece of property, I could put it in a revocable trust
A revocable trust, something you can change.
for my kids. When I croak,
Uh-huh.
that'll be the asset that I'll have will be my property.
That's the way.
So, in the interim, it's a revocable trust. The property taxes due every year, I presume I pay those,
Correct.
and there won't be any income from the property, so it's not gonna rent it out. So basically, it's a tax, during the interim. I pay taxes on the real estate once a year.
Your property tax.
Property taxes, yeah. Are there other taxes in a situation, simple situation like that are due by me? The trust don't have any income.
Right, because now if it did, i.e. you put it on Airbnb and you rent it out, you get rent, obviously you have to pay the rent. So,
Yeah,
so let's say that you live in Florida and you have a piece of property in Windsor,
Okay,
and so you now don't live in the state of
Okay.
Vermont,
Yep.
but you have this property and it's in a trust.
Yeah.
And you die. It's subject to Vermont estate tax.
gotcha.
So,
Um,
and all the tangible personal property in it. So.
Okay.
Subject to Vermont state taxes.
Estate tax, yes. We can tax two things within our borders, which is we can tax land and tangible personal property. But if, let's say that the person in Florida owns a corporation in Vermont and they have stock in it, the stock is an intangible, so that belongs to the domicile where the person lives. So really back up this, and I tell all my clients this, we sort of get property 101. Two types of property: real property, land, and any building that's attached to it. Everything else we call personal property. Okay, personal property comes in two flavors: some stuff you can touch and stuff you can't touch. Stuff you can touch: furniture, forks, knives, spoons, your clothing, jewelry, guns, cars, that sort of thing. And stuff you can't touch: bank accounts, your retirement account, that sort of thing. Okay, so now that's property. Okay, let's to title. Title, we have a system of title. Well, I say finally, it used to be in the feudal age, the way they transferred title was the owner would scoop up mud and put it in the owner's hand. Said, you now own the property. They just transferred mud. But then came reading and writing and, registry of deeds and stuff like that. So now all real estate must be conveyed in a writing. And you can't orally transfer land. Okay. With regard to tangible personal property, we have no system. It's the Wild West. And that's why people steal it. They steal paintings, they steal electronics, they steal your car. Well, your car is the only thing that has a title certificate usually. And then it's only if the car is, under 20 years of age. So we don't really have a system for tangible personal property. And then intangible personal properties, when you open an account, the financial institution or whatever institution will say, okay, who's the owner? And you write it down. So we do have a system as we know who owns the property there. So
Representative Higley.
So the previous speaker had talked about, and maybe you've talked about, I just haven't heard the words yet, a resident trust.
yes,
Difference, he's saying, and we need to maybe consider a definition of resident other than what we have now. That makes sense?
yeah, it does. So a resident trust is a Vermont income tax concept. So because it's embedded in our I think it's 5811, 32, 5811, and it's section 11, I think, there. And basically they're saying in that section that the income from a trust is taxable by the state of Vermont if the contributor to the trust, doesn't use the word contributor, but basically it's saying so it doesn't necessarily have to be the donor, grantor, settlor. If anybody else, if another person gives money to the trustee, for whatever the terms of the trust are, they could be a contributor. And if when that person dies, they are domiciled. No, wait a second.
It's careful to stay away from the word domicile.
No, the way that it works is if there is a contributor who was a Vermonter at the time of the contribution, and the trust becomes irrevocable, I think while they're a Vermonter, then that contribution and any income that's generated from it would be subject to Vermont taxes. Okay, that's the concept that, and this statute is very akin to Connecticut and New Jersey. I'm not sure about New York. So we do tax, so it can be a resident trust if the contributor was domiciled in Vermont at the time the trust became irrevocable.
Representative Holcomb.
I'm just curious how you would even disattenuate that if there's multiple contributors to a trust and it's invested. Do you have to go back and look at the basis? of the
Absolutely.
funds?
Oh,
You
no,
have to
not the
track
basis,
everything?
but who contributed what?
But how do you? Record keeping there.
Yeah, it's a record
Because
keeping.
you have to look at the specific, I mean, I'm just trying to even imagine how that would work. Let's say Jim donates, Mark has a trust for his kids and Jim donates to the trust for Mark's kids, $10,000 and that trust invested in
Huh?
stock. Is it based on the stock that was bought with Jim's donation?
Yeah, if he's in the state domiciled when the trust becomes irrevocable.
Yeah. And Carolyn also donated 20 and she bought really bad stock that didn't do as well. So the basis wouldn't have grown as much. You would be able to disaggregate back to. the
Yeah, you have to-
individual investments.
Yeah, it's transmuting.
Record keeping.
Yeah, it's, but the,
Why do we need lawyers and accountants?
well, I'll give you an example of record keeping.
Yeah.
So we have two systems of marital property in the United States. We have the English system, and we have the Spanish system. Those states that were settled by the Spanish and the French, because this is actually a German concept called community property, and that the continent of Europe has adopted it, but not the English. So, and what community property says is that anything you walk into the marriage with is your own separate property, and anything that you inherit from your family or get a gift from is your separate property, and your spouse has no claim against it in the event of divorce or death. Okay. Anything you earned earned during the marriage, it goes to the community estate and both of you own it 50-50. So that, let's say, in the old fashioned days where the wife stayed at home and raised the kids and the husband goes out and earns all this money, well, the theory is he can only do that because she's there pulling her weight, that enables him to go out and earn money. So she's entitled to half. That's that's a community property state. But it turns out that, getting to your point is in community property states, California, New Mexico, Arizona, Texas, they have to keep 3 sets of books.
Yeah, it's amazing.
Yeah, what's my separate property? What's your separate property? What's our community property? So sometimes, it's rare when you have multiple contributors that aren't, I don't know of many cases that have really happened. It's infrequent. So it's one of those rules that, it could be a nightmare, but it rarely occurs because you don't usually have third-party contributors coming into the trust. So with resident trusts, okay, so here's what's going on with resident trusts too, is that what happens though, where I'm seeing the cases on is that, so the contributor is dead now, okay? And let's say the trustee is out of state and all the beneficiaries are out of state. Why should Vermont be able to tax that trust? Because nobody's in and maybe even the assets are out of the trust, are out of the state. Why should the Vermont be able to tax it just because a contributor contributed at one point into infinity? And we're now starting to see a bunch of cases percolating up through New Jersey, Connecticut, and some of the other states. They're saying, no, we look at the judges are saying, we look at these at tax by tax basis. So maybe the first year, yes, because your contributor, just died and the contributor was there and it was irrevocable. But now if a trust loses the ability, it's touching its nexus with Vermont, then maybe Vermont shouldn't be able to tax it any longer. And that seems to be going the way where the law is developing. There was a case recently by the name of Kessner that was decided by the United States Supreme Court that Judge Thomas wrote the opinion. And basically it was, North Carolina was trying to tax this trust and nobody was in North Carolina. It was just, it had a historical root, but nobody was in it. And the court said, no, I think there was a beneficiary in the state and they were latching on, North Carolina was latching on the fact that they had a beneficiary in the state. But the beneficiary was totally discretionary. They had no rights. They were at whether the trustee distributed income or principal to them, they couldn't force anything up like that. And the United States Supreme Court said, you're lacking nexus. You have to have nexus to be able to tax that. So as I said, in Vermont, we can tax real estate that's in it and tangible personal property. A lot of people didn't know this rule, but it's a great case. It's the Commonwealth of Pennsylvania versus Frick. Maybe you remember the name Henry Frick. Mr. Frick, he was from Pennsylvania, Philadelphia, and his art collection was sitting in the Frick Museum on Fifth Avenue. And Pennsylvania wanted to tax it. And the United States Supreme Court said, not so fast. You don't have nexus. You don't have that tangible personal property is not in even though it's movable, they said, we don't care if it's movable. It wasn't in the state when he died. So if your tangible personal property is out, it wasn't, but if it's in, it is. So I had a decedent who died with a house in Manchester. And usually we don't pay attention to the tangible personal property. It's usually not. But she had a painting worth $2 million. So we reported it and we paid the Vermont estate tax on it.
Thanks. Sell the painting just to, settle, yeah.
Right.
You don't have a basis.
Well, thank you.
Okay. Thank you.
Thank you, sir.
You're welcome.
There's more questions I've given them. They know what they are. Hopefully see you again.
Okay. Be happy to go. Well, I might be down for S-170.
Thank you.
You mentioned my book of house.
Yes.
He started it. So it's my mother's story. And it's also.
Thank you very much. Can I ask a question?
I'm sorry.
Vice Chair,